You are not only a person who is well versed in law, but you are also a strategist. So, what do I mean when I say that you're a strategist? At any point of time, you will find multiple options open to you. And how do you take a call on which option to follow and which option not to follow? To you, it might appear as if all options are equally attractive. And it is true that there is a multiplicity of very, very attractive options open in front of you. That's a fact. And yet, I would venture to suggest that don't get carried away by the attraction of law. Law is a very attractive calling. It is very intellectually stimulating. And you can begin to focus on yourself as a lawyer rather than focusing on the needs of your client. So the first thing that I have to tell you is that always remember that you have to focus on your client, not on yourself. And the first thing you need to do is to do a needs assessment of what your client really and truly needs. Never use your client as a guinea pig to take up issues which are dear to your own heart. It happens very often in the field of public interest litigation. But you must remember that when a client is sitting in front of you in flesh and blood, that person has her own needs. And your needs may not coincide with the needs of that person. So your first duty as a lawyer is to identify the needs of your client. And when you begin to do that, you will find a multiplicity of options opening up for her. And then you will be faced with the second challenge as to, of the several options, which is the best option. You will have to ask yourself the question, should I exercise more than one option? Should I focus only on one option? And my recommendation, of course, will be that all these decisions have to be taken in consultation with your client. These are not individual decisions for you to take. So, you have to place before your client all the options. You have to tell them the pros and cons of each option. And then, to some extent, you have to leave the decision of which option to take to the client. Now, why do I say that? Because it's a question of readiness on the part of the client. You will win or lose your case dependent on various factors, but one of the factors is the readiness of the client to see this issue through to its logical conclusion. So, these are two different strategies that I am suggesting. Now, I move on to the next one. I am told that in yesterday's session, somebody raised the issue of misuse of 498A. Now, let us deconstruct this word misuse, because you are sitting in the chair of a lawyer, a client is in front of you. And my question to you would be, assuming there is misuse, who is misusing the law? Is it the client, is it the lawyer, or is it someone else? Of course, first you must know what is the meaning of the word misuse. Can anybody answer to that? What is the meaning of the word misuse? I would prefer to say, is it a false, if somebody has brought a false case, perhaps an argument could be that you are misusing the law. Now, why? Because the law is meant to be used for the right purpose. So that is my third guidance to you as a lawyer. Use the law for the purpose for which it is meant. And very often when I have been sitting and looking at what's going on around me, I do find that lawyers have a tendency to advise their clients to exaggerate their case. Lawyers have a tendency to advise their clients to go to the extent of lying about their case. Well, I can only tell you as a seasoned lawyer that that strategy is doomed to fail. For the very simple reason that we have an adversarial system of justice, and another seasoned lawyer on the other side can identify your lie in a matter of seconds. So can the judge. He's sitting there. Ask him. Ask him whether when a case comes in his court, whether he has a judicial intuition about the facts of the case. And I use the expression judicial intuition, not just any intuition. These are trained people who can tell the difference between, that is their job. The job of a judge is to tell the difference between a truth and a lie. They are fact finders. They are investigators in a certain sense of the word. And they are decision makers. So we can hear a little more about this whole judicial process, the judicial mind, and how does one come to certain conclusions. But at the moment we are concerned about you as lawyers. And I have always taken the view throughout my career, and I've survived till this age, that it pays to tell the truth. I can tell you it's a winning strategy. When you are sitting on your desk and drafting a plaint, you may think, oh my God, if I admit to this, I will lose the case, but you won't. You just won't, because there's always a way in which you can present a case very, very truthfully and win your case. It's very simple. All you need to know is what are the potential arguments on the other side and take them on board in advance while drafting your petition. This is the next piece of advice to you. While drafting your petitions, be aware of what the other side is going to say. And don't try to deny it, but deal with it. Deal with it in your petition. I have always used this strategy. I co-opt my opponents. I don't give them an opportunity to come out with their case at a subsequent stage where I then become the person who has to explain what their case is. What I do is, in my petition, I already explain the case of the other side. And I deal with it. So that when that person has to file their written statement, they have to deal with my dealing of their dealing. In other words, you are what we call in law the dominus litis. Dominus litis means you have control over the case. And as now, of course, I must qualify that everything I've said to you is assuming that you are the lawyer for the first mover. But you must never lose your advantage as the first mover of the case. And you will lose that advantage if you try to play games as the first mover, if you try to conceal what appears to be against you instead of dealing with it. I mean, for example, if there's a delay in lodging the complaint, all right, there's a delay in lodging the complaint. But if you deal with it in advance, instead of waiting for the other side to say, oh my God, look at her, she filed a complaint after 10 years. I mean, where did I read? Yesterday I read in the newspaper the Supreme Court reopened a case which was 1,690 days old, the Ayodhya case against L.K. Advani. So you're not going to sit there and struggle and say, no, my case is within limitation for this reason, that reason, whatever. Of course, there are laws to be dealt with. I'll come to that in a minute. But I mean, I have seen lawyers who when the client is sitting with them, if it's a 498A case, they will tell the lawyer, लिखो लिखो dowry दिया, नहीं तो आप पुलिस आपका complaint नहीं register करेंगे. Now this is not only ignorance of law, because 498A can be activated without any complaint of dowry, but it's also a falsehood. And so I would recommend that you don't go for those strategies. I recently came across a case of an 80-year-old woman, a lawyer who sent a notice to, not 80, she was about 70-year-old woman, accusing her, saying that she told somebody that I'm going to file a false case of rape against you. Now that allegation was false. The lawyer falsely wrote in his legal notice that the lady to whom he was giving a legal notice had threatened to file a false case. Just look at the cleverness of lawyers. Look at the cleverness of lawyers. The shoe is on the other foot. Normally the women are being told that you are filing false cases against men, but here's a lawyer who uses the knowledge that there is a prevailing issue in society, that women are misusing the law, and he uses it to his advantage in a legal notice, thinking that everybody will believe what I'm saying, but because in any case women misuse the law. So lawyers have to have a code of conduct. Somebody brought this up in the meeting yesterday, that what is the code of conduct that we follow, what are the ethics that we follow. And what I'm trying to tell you is good ethics also makes good law. And these are winning strategies. That's what I'm trying to tell you. And if you keep these background notes in mind, then we now move on to some of the other things that you need to be aware of before you start litigation. So here we go. In sexual, the following laws are relevant. See, you'll have to be aware of all these laws. Civil law, you might want to file a suit for damages. Constitutional law, you might want to file a writ petition. Criminal law, you might want to go under 354A. There is the Vishaka judgment, and in the morning also I raised the issue. There are outstanding issues about implementation of the Vishaka judgment. You have the labor law, you have the service law, about which there are going to be discussions right now. And what you need to do is check what remedy is available and choose your remedy according to the needs of the client. You might even want to exercise more than one remedy at one time. I'll give you an example of when such things do happen. You can use more than one. Check if the court has jurisdiction to entertain the suit. In a civil suit, as per section 9 of the Civil Procedure Code, civil courts have inherent jurisdiction unless an exception is made by any statutory provision. Now, this morning Justice Ravindra Bhatt brought up this issue, and he said, in his opinion, it's a very good thing that there is no remedy provided under the Act, because you can experiment with any remedy you want to experiment with. So here is one of the remedies you can experiment with, section 9 of the Civil Procedure Code. And if I'm not mistaken, I don't have the citation, but long, long ago, Justice Chandrachud, the senior Chandrachud, gave a judgment in which he said, it's a judgment under section 9, in which he said section 9 can be used to vindicate any and every grievance and any and every wrong. So this is one thing which you cannot afford to forget. And for those of us who do not live within the jurisdiction of high courts, this is a very, very important thing to remember. It is very easy for us, if we are located within the territorial jurisdiction of a high court, to say we will use Article 226. And for those of us who live in the territorial jurisdiction of the Supreme Court, to say we will use Article 32. But there is always section 9, and you can always go to the court nearest to your own doorstep. Next. Now, what are the things you need to remember? Pecuniary jurisdiction. The Suits Valuation Act of 1887 prescribes the mode of valuing certain suits for the purpose of determining jurisdiction. Under Section 8, the valuation of court fees and valuations for jurisdiction is the same in certain suits, including suits for damages. Now, there is no doubt that this court fees are payable on every civil suit that we file. See, you can file a suit for damages for sexual harassment at the workplace, for mental, physical, and emotional injury, for causing what is known as intentional emotional distress. And you can claim damages if you want to. I know many women who've said, we don't want any money for the sexual harassment that we've suffered. But in many countries of the world, it is the primary relief which is granted in cases of sexual harassment at the workplace is huge and hefty damages. And huge and hefty damages payable both by the employer and by the person jointly and severally. That means both are liable. Now, I don't know why under your Sexual Harassment Act, yours meaning ours, our Sexual Harassment Act, it says over there that even during conciliation, it cannot be settled with monetary relief. Of course, it intrigues me a lot as to why does it say that you cannot have a settlement on a monetary basis. Because when it comes to the law of tort, the only remedy that is available is a remedy in damages, money. It may be 10 rupees, it may be 1 rupee, it may be 10 lakhs, it may be 10 crores. And there's a huge jurisprudence on this as to what is the amount that should be paid by way of punitive damages or by way of any other damages. That was the whole issue in the Bhopal case also. In the UCC case, what was it all about? Okay, but this is also a big deterrent. Move further. It's also a big deterrent because court fees are payable on the amount of damages you claim. In a civil suit for damages, Section 7(1) of the Court Fees Act is relevant. The amount of fee payable will be according to the amount claimed. Every state has different amounts specified as court fees. For plaintiffs who are unable to pay, the CRPC does have a provision of exemption under Order 33, Rule 1. Under Section 12 of the Legal Services Act, all women are entitled to free legal services under the Act. So, although you are liable to pay court fees unless you sue in your capacity as a pauper, indigent, there is, but you know, many of us, when we sue, we don't qualify as indigents, and yet we can't afford the court fees. So, it's an issue that needs to be addressed. Now, one way to address it is that Section 12 of the Legal Services Act has an unqualified right that all women are entitled to legal services free of charge, regardless of any means test. Now, I am not aware whether this will include also payment of court fees, but it's a matter worth.
What they do is, if she gets monetary relief, it's
Adjusted. All right. So, this is a very important provision for you to know in case your conceptual litigant or hypothetical litigant wants damages. Next. Now, the other thing you need to know is jurisdiction. A survivor can record a 0 FIR irrespective of jurisdiction in any police station, and the information will be sent to the police station with jurisdiction to investigate. The Supreme Court has held that the case of cognizable offences, police cannot refuse to register an FIR on the ground of lack of territorial jurisdiction. The police is bound to take necessary steps and commence investigation. Offences under 354A is cognizable, bailable and triable by a magistrate. So, these are things you need to be aware of before you even begin your litigation, you begin using your legal strategies. Now, we know this, I'll skip over it. Article 32 and 226 guarantee the right to move the Supreme Court. By the way, all of you know that Ambedkar said that Article 32 is the heart of the Indian Constitution. And this is my own personal belief as well. It is the only court in the world, the Indian Supreme Court, that allows direct access to the Supreme Court is the Indian Supreme Court. because of Article 32. No other court in the world can you approach directly. You have to go step by step from the court which has the lowest primary jurisdiction through the appellate procedure, through the High Court to the Supreme Court. And that is the reason why Ambedkar said that Article 32 is the heart of the Constitution. Because he recognized that in a country like India, to compel a person to go through the whole judicial process is not going to work. By the way, this is also the basis of PIL jurisdiction. I will shortly tell you. So it's an amazing article in the Constitution of India, and it has been successfully used by many, many people. Just to elaborate what Ambedkar said, it was Justice Bhagwati when he for the first time elaborated what is public interest litigation. He said, the inherited legal system of this country is based on the adversarial mode of dispensing justice. It is not suited to the genus of the Indian people. He said the precondition for that is self-identification of injury and self-selection of remedy. And conditions simply don't exist in India where people know what their rights are and what remedy to select. That is the reason why we need public interest litigation. And it happened through a procedural innovation. The procedural innovation was waiving the requirement of locus standi to the aggrieved person. And this ties into a question that was asked to me in the morning. I think Abhisheka asked this question. Whether a complaint of sexual harassment can be made by a person who is not aggrieved by sexual harassment. The answer is yes, it can be. So the significance of waiving locus standi and not limiting it to the aggrieved person is revolutionary. It has a revolutionary impact on the whole legal system of the country. And this is what was done by Justice Bhagwati when he came up with his theoretical foundation of public interest litigation. Well, I'm very sorry to say that in today's world, the young lawyers, they refer to it as pill, right? As if it was a pill which you take when you get a fever or whatever. And if you ask them what is the meaning of pill, they cannot even tell you that it's an abbreviation of public interest litigation. Leave aside knowing what public interest litigation. I've asked many people, what is this pill you're talking about? It's a pill. A pill is a pill. Why are you asking us what is a pill? They don't know that it stands for public interest litigation. This is just to give you an example of how short public memory can be. I belong to a generation that was deeply influenced by people like Krishna Iyer and by Justice Bhagwati. But decades have gone by after that, and the people who come now are using public interest litigation without knowing the instrument they are using. So it all goes back to strategy. I would suggest you go back and read S.P. Gupta's case, read the Asiad judgment, and please understand what public interest litigation is all about. So moving on from 32, the remedies are available only against the state. Justice Ravi Bhatt dealt with this. And Medha Kotwal's judgment also has been dealt with. The writ petition can be filed for failure to conduct an inquiry in terms of full compliance with Vishaka in the public sector. Next. Now you have to deal with issues of standard of proof. Again, maybe Justice Kannan will come in on this. Standard of proof differs in civil law and criminal law. You should all be aware of it. Civil law, it's balance of probabilities. This requires that the dispute be decided in favor of the party whose claims are more likely to be true, but there are degrees of probability between the standard depending upon the subject matter, that is fraud or negligence. Now, criminal law, beyond all reasonable doubt. The proposition must be proven to the extent that there could be no reasonable doubt in the mind of a reasonable person that the defendant is guilty. in a number of cases, contradictions in deposition statements have led courts to say case was not proved beyond reasonable doubt. Now, brings you back to the question, how will you choose your remedy? When you're choosing your remedy, be conscious of what the remedy entails. Be conscious of the fact that when you're doing a criminal case, the burden of proof is on the prosecution. Be conscious of the fact that the state will be prosecuting and not you. But of course, also be conscious of the fact that in today's context, the role of the survivor has expanded, and you can now actually participate in the litigation. Whereas in a civil case, you are the dominus litis. You cannot be dislodged by anybody. And this is one of the reasons why I, for myself, have preferred civil law to criminal law. Next. Of course, be aware of limitation. Unfortunately, under the Sexual Harassment Act, the period of limitation for filing a complaint is 3 months. There is a provision for reasons to be recorded in writing to extend the period of limitation beyond 3 months. Limitation period for offences under 354A is 3 years. Again, you see the contradiction here. 3 months and 3 years. So why should the limitation under this law be only 3 months? And this is a major issue because women facing sexual harassment are not able to come out with their story perhaps within a period of 3 months. And therefore, this limitation appears to be too restrictive. The only saving grace is that it can be extended and by 3 more months. But again, I know of cases where even 6 months is not enough for a woman to come out. But now that you have the act in front of you, please be aware of these issues, and if you have a client, please make sure that the complaint, you advise them to file it within the limitation period. Now, there is no period prescribed of limitation for writ petitions. Different judgments, however, have held that the court will come to the rescue of only those who are vigilant, and a petition filed after the expiry of the period of limitation prescribed for filing a suit will not be entertained unless cogent explanation is offered for the same. There is no upper or lower limit for filing a writ petition, and each case has to be decided on its own facts. So very often we prefer writ petitions to suits because this is one of the reasons. Next. I'm now going to move, I'm sure this is can go on and on and on, but I'll leave it to Justice Kannan to clarify all these, the judicial mind. One thing I've not done in my life is become a judge. I've done everything else, but not that. But I'm now going to take you through a few issues that you should be aware of, and that is, in terms of strategy, always anticipate what your opponent might do. So I'm now going to move on to you to tell you what can happen and be prepared for it. Be aware of the fact that you may have to deal with counter suits. For example, defamation suits can be filed in the case of sexual harassment. The respondent may also seek an injunction against the publication of facts of the case. Hence, be aware of the law relating to defamation, both civil and criminal. Now, this is not to say that you should not disclose the facts. It's only to say that be clever enough to know the law of defamation and to word your document accordingly, that nobody can accuse you that you have defamed another person. So be aware that truth is a defense. Be aware as to what your defenses to defamation could be even before you put pen to paper. Okay, so these are various strategies, and this kind of thing is possible, inevitable. We are all aware, or should be aware, that in matrimonial disputes, when NGOs try to go and help a woman, they enter the matrimonial home to take custody of the child. There can be allegations and criminal complaints of criminal trespass. filed against the NGO. And it has happened in many cases. So in such cases, we always advise, I mean, you must know this in advance, so we advise the person, lodge a police complaint before you go. When a woman wants to leave the matrimonial home, we tell her, you lodge a criminal complaint with the police station while or contemporaneously with leaving the home. And, you know, give them proof that you're a married woman, this is your child, you have lawful custody of the child. If there are any court orders, keep them with you at all point of time. Next. Criminal cases of kidnapping, I've said this already, against many NGOs have been dealt with, especially in cases involving child sexual abuse. In such cases, of course, it's always advisable to have a custody order in advance in your own favor. Criminal attacks on human rights lawyers and NGOs must be aware that in extreme cases, women are attacked for choosing to marry outside their caste or community within the same gotra. Hence, if a client comes to you in relation to a marriage without the consent of the family, ensure that the marriage takes place in another jurisdiction. Now, some might debate this, say that this is unlawful advice, or within 30 days through Arya Samaj marriages. The idea that I'm trying to portray is you must be aware that any step you take will have a counter step and will have consequences, and you must take that on board before planning your strategy. Safety and security of human rights defenders, if you deal with sensitive cases, the good idea to have CCTV in your office, this of course, and entry into the office only for authorized personnel. Secure all your communications if you believe that a third person may be listening. I have done a sexual harassment case where emails exchanged between the lawyer and the client have been hacked into and copied and then returned to the email account. Okay, all this is going on. During the course of litigation it happened. Never overstate your, even like Greenpeace for example, when they deal with their communications in between staff, they are all encrypted communications. All of you are very familiar with the case of Edward Snowden, I hope. There's books written about this issue. Never overstate your case. This of course is a general thing, and I will give you some examples of it. You can fall flat on your face if you overstate your case. You do not have to give substantive response to every allegation made by the respondent against you. You can simply say, I am not aware of and do not admit, in order to avoid getting into a trap set for you by the respondent. If you're clever, of course, you'll be able to make out from the way a written statement is filed that your opponent is setting a trap for you. And you must know how not to walk into that trap. A case is a case. Be aware before filing it. There's something known as issues in a case, which are drafted during the hearing. But the point is that even before you draft your petition, you must know what are the issues in your case. I've been telling people, even after the pre-appellate judgment, somebody asked me, how did you hit the nail on the head? So I said, well, what I do is I write the judgment in my head in advance, and then I go backwards and I draft the petition. It is possible to do it. You can actually direct the judge to give, I'm sorry, but you know, I don't mean to be dismissive of the judicial function, but you can actually direct the outcome of a case in the manner in which you draft your petition. I'm trying to emphasize to you the importance of drafting a petition. That is the real mystery. How did the lawyer draft that petition? I am a person who believes that you've won or lost your case depending on your draft. That's it. And not even draft, it's on your legal notice. You give one legal notice and you've either won or you've lost your case. Finished, it's over. Because in your petition, you cannot improve upon your own legal notice. I have won cases against the most powerful employers in this country, just on the basis of one legal notice, nothing else. I did a case against Indian Express in Bombay when all the workers had gone on strike, actually. And the employer moved the High Court on all these injunctions, etc., etc. At that stage, all I had to do was produce my legal notice. I said, see this legal notice, which I sent before they started their proceedings. What was their reply to this? And in their reply, they had admitted half the things that I was wanting to prove in court. You see, you have to understand the importance of the written word. Law is about the written word. It's not about anything else. And you must understand the importance of the written word. So legal notice serves many purposes. Apart from the fact that under the law, when you go and ask for a mandamus, you will have to show, did you make a demand for justice, was justice given, not given, etc. You have to give that legal notice before you go to court against any public sector. But it's very important for you as lawyers to know these things and I personally believe, when I say never overstate your case, personally I believe in a minimalistic strategy for litigation. Litigation is a war. So you don't just go into the battle with all guns blazing, and nor do you try to kill a fly with a sledgehammer. Okay? So you have to be very careful how you use legal strategies in court. You know, be minimalistic would be my advice to you. Don't say, I have 100 options open to me and let me use all of them. You will fall flat on all of them. You do not have to give substantive responses, I've already told you. Here again, people tie themselves up in knots. Oh, he has said this in the affidavit, now what do I reply? What do you reply? It's not an issue in the case, why are you replying? Don't reply. Just say, I am not aware and I do not admit. Understand the importance of pleadings is what I am trying to tell you. Learn how to draft good pleadings. Then, decide what is your core issue, the same issue, at the stage of drafting, and stick to it throughout the litigation process. Don't try to change course in the middle of the case. So here's the definition. It's a strategic lawsuit by your opponent. It is a suit filed against you which is actually never intended to be won. For example, you file a suit for injunction and claim damages against workers, the whole world knows you're not going to get damages from the workers. Okay? But you file it anyway. It's an intimidatory tactic. So, there are many such legal intimidatory tactics. Two of them I've already pointed out to you, a suit for injunction, a suit for defamation, etc., etc. I mean, even the person filing for defamation knows that it's never going to reach any logical conclusion. You get an injunction and sit there for the next 10 years, 20 years, by the time everything is forgotten, by the time everything is over. But it is a kind of a legal terrorization of the opponent. And your whole energy and your whole attention is diverted towards defending that suit rather than focusing attention on the main suit. So this is what is called a SLAPP suit. And in some countries in the world, there have been strategies and laws which have been framed to prevent SLAPP suits so that justice is properly done, so that the issue is focused on the main issue. Just one or two examples I'll give you and leave it at that, and then the rest of you have to figure out. As I told you, a woman wants custody, you could just go and file a house trespass case. How many people I know who have filed cases of kidnapping against their wives for having taken a child out of the custody of the matrimonial home? There is a whole Hague Convention on this. It's called the Hague Convention on Child Abduction. So a mother can be accused of abducting her own child. Okay, so when things like this happen, you need to know how to deal with it, and of course you need to. I'll just show you those couple of slides on SLAPP suits. I'm sure many of you have faced these examples of basically it's a form of retaliation, but you know, you can expect retaliation on the ground, but there are legal forms of retaliation also, which you should be simply aware of, because you know that's the nature of the law, that's the nature of the animal. The law can be used by both sides. You have to understand, the law can be used by both sides. Sometimes when you talk about rights, you must understand that it's again a triangulation, and other people can also claim that they have rights and use the same law. I mean, most of the successes I've had is by using the same law that the other people use against me. I can use it successfully against them. But the general instructions given are that if such a suit is filed against you, of course contemplate it in advance as well, but then you have to try and prove to the judge that that is a measure of retaliation. And many countries actually have dealt with it successfully and held that this is a measure of retaliation and have not taken it very seriously.